I'm going to begin with the following hypothetical. Let's say the president, some future president, demanded the DOJ to pay him 100 million smackaroos. No, let's not do that, because I'm not sure that any theory of unitary executive can deal with that. Actually, my panelists can address that later if they want. They can work that in. I just had to add that last night. Okay. What I am going to do is I'm going to try to frame the issues, because the unitary executive theory and unitary executive is sometimes used in a cartoonish way. So I'm going to try to distinguish two groups of executive branch claims. And the first one I'm going to call the core or traditional unitary executive doctrine, and it involves the president's claimed unencumbered power to decide things within the executive branch, to be the final decider, to call the shots. It is his power to superintend the executive branch, and it involves issues like, can Congress create independent agencies that exercise executive power and insulate the president from that decision-making power? That's a more controversial one that involves ultimately whether Congress can create limitations on presidential removal power. It involves the Fed, involves the Federal Trade Commission. There's a couple of famous Supreme Court cases you all know about, and the Supreme Court is revisiting one. We're not going to ask Ahmet will be arguing one of those cases, but we're going to ask general questions so that he doesn't get in trouble. But some rather conventional applications, and then I'll skip to the other one, is Ronald Reagan first issued an executive order requiring regulatory agencies to submit their draft regulations to OMB, a new Office of Regulatory Affairs. And this was seen as very controversial for centralized review, for White House review of draft. But a law professor who I had at the University of Chicago, I don't know if some of the, Cass Sunstein thought this was somewhat controversial, but then Cass Sunstein became the head of that in the Obama administration. It's rather conventional. Yes, the president can at least, and it's been expanded, can engage in some centralized review. So anyway, that's one of the kind of claims. The reason I'm making this distinction is, as originalist, I think the arguments, there's a variety of views on these, but the arguments for this type of claim is different from the second one, and as an originalist, I think it's a little bit stronger. So the second area I'll call the president's prerogative powers, or absolute prerogative powers, and two that are actual textual are his right to veto laws and give pardons, and these can have effects on the rest of government. But there is an argument that the president can exercise other prerogative powers that aren't necessarily expressed, and that these can trump law. He can dispense with laws, as in TikTok. He can impound funds if it affects the exercise of his other executive powers. And let's see, AI's definition I checked of prerogative powers is the president's power to act at his discretion for the public good without specific legal prescription and even in opposition to existing law, especially in emergencies. So anyway, let me begin, and we'll get into some other specific questions and we'll go from Shannon on down. Do you think this distinction is helpful in answering some of the questions about the unitary? Does it make any practical difference, or was I just wasting everyone's time?
The latter, I'm sure. No, there is, and I think these guys can talk to this, there is sort of a cartoonish perception of the executive power, which I have always thought of as coming from the left, and these guys will tell you is now coming from the Trump administration, and I think it's an interesting development. But the unitary executive theory I have always thought of as the conception of the president being able to superintend all executive power vested by the Constitution. Now, this comes from the vesting clause of of Article 2 of the Constitution, which just says the executive power shall be vested in a president of the United States. That's interesting in a couple of respects. First, there was a question of, does Article 2 just establish the executive? No, it does more. It says, all of the power is vested in the president. If you compare that to the vesting clause of Article 1, there's language in Article 1 that's much different. It says all of the legislative powers basically described herein are vested in the legislature. So Congress's powers were meant to be completely enumerated in the Constitution. There is at least, a theory that this vesting clause of the executive power, involves some unenumerated powers of the president. That is, what the executive powers were meant to, were understood to mean at the time of the Constitution's enactment, and but qualified in some senses, like executives could declare war in many countries at the time, but that power is vested in Congress by this Constitution. But what we think of now, what's really being debated and what these guys are really involved in now is the issue of, okay, there is an executive power, it's vested in the president, and at least, since my time, the Reagan administration and certainly the George W. Bush administration, we were very careful to try to prevent impingement on that power by Congress. So there are all sorts of federal statutes that Congress grants powers that might be viewed as executive power, and you think of one that every president has objected to, the War Powers Act. There, you have the line between the Congress's power to declare war and the president's power as commander-in-chief, but every president has said, I can send troops off into some level of engagement in other countries without it being a war, and that's simply part of my executive power. And Congress's attempt to regulate that, the president's view is unconstitutional. Never been forced in the courts, probably a political question anyway, but every president since the enactment of the War Powers Resolution has said, yeah, we'll, as a matter of courtesy to Congress, report to Congress as required by the act, but we don't have to do this.
So I guess, is this, do I turn this on, or what do I do here? There we go. Can everyone hear me? Yes. Okay. So I guess my view is I don't think the taxonomy is useful for the following reason. I think that at the end of the day, the executive branch is viewing its prerogative power as extending to every aspect of the executive branch, and it doesn't think it can be constricted in any possible way. So let me give you an example, and I think if the question for this panel is, should you rethink the unitary executive, my answer is yes, in light of recent events. So let me give you an example of the cartoonish theory in action. It's about removal, but it's not about Amit's case and the removal for independent agencies. It's about the removal power of the president and the heads of department for the 4 million inferior officers and employees throughout the federal government, the nonpartisan civil service, the people who make sure the lights are on at the CDC, the NIH, line attorneys at the Department of Justice, people who are sweeping the floors of the Department of Agriculture. This administration has taken the position that because of the vesting clause, they can fire pretty much whomever they want, whenever they want, for whatever reason, and that Congress can do nothing about it. So there's a real case right now where the Department of Justice, its own EEO office, recently issued a decision that said because of the president's Article 2 removal power Title VII is unconstitutional with respect to this employee. So that means that the president, under this administration's view of executive power, the president has the constitutional right, they think, to engage in racial discrimination, sex discrimination, religious discrimination, and Congress and the Constitution, the First Amendment, can say nothing about it. That's gotta be wrong. It also has no basis in American history or precedent. There's a case called Perkins from the 1880s, in which the Supreme Court says, in the United States v. Perkins, Congress can regulate inferior officers. Can't do it potentially for principal officers. That's Ahmed's case in Slaughter, but no question they can do it for inferior officers. In United States, in Myers v. United States, the high watermark for the removal power, Chief Justice Taft goes out of his way to say, you know, when Congress establishes inferior offices or employees, no question they can regulate removal, citing Perkins. So I think we've gone off the rails and the deep end of the conception of the unitary executive. And so if the question is, should we rethink it, I think recent events mandate it.
Thanks. Great to be here today. Good to see everyone. I'll start with the proverbial or obligatory disclaimer that just speaking today in a purely personal capacity and not on behalf of any client or my organization. So I basically agree with your take on these issues, and I guess I would just add a couple of thoughts. So first, I think as a matter of first principles, I don't have any quarrel with the unitary executive theory, at least benign versions of the unitary executive theory, and I think the way that you teed up this discussion, it can be helpful just in terms of identifying different categories of issues in which we have to figure out what is the scope of the president's executive power, and to some extent I think that taxonomy can be helpful, but I basically agree with Nate, and here's the thing that is really frustrating, I think, for me, is sometimes the unitary executive theory, it seems like it is advertised on one basis and sold to the public on one basis, and a basis that is sort of very benign and even maybe unobjectionable. And that unobjectionable version basically just tracks the plain text of the vesting clause of Article 2, and it says, the executive power shall be vested in a president of the United States, and therefore the executive power, whatever it is, must be vested in the president. The president controls it. And that's fine, but it sort of begs the question of what is the scope of the executive power? And so I think with respect to, so that's the way it's sold sometimes, to seem like, oh, this is just unobjectionable. But where it's being applied in practice, and we see this day after day after day, and context after context after context, is things that are not unobjectionable, things that are talking about taking institutions that have been around for sometimes more than 100, 150 years, and just tossing them out the door, taking laws that have been enacted by the people's elected representatives and that have been upheld, sometimes unanimously, by the Supreme Court of the United States, that all three branches of government have acquiesced in for a really long period of time, and saying somebody can show up with the maximalist version of a theory, and that our overarching commitment at the end of the day should be to that maximalist version of the theory. Now, this is all at a really high level of abstraction, right? So I want to make a little concrete, just like Nate did. What are we talking about in practice? We're talking about things like, can a late night comedian speak his mind without having to be afraid that the network license is going to be pulled because he has said something that the President of the United States does not like? That is not an abstraction. It's not a theory. That is a shared lived reality. It is something that as Americans we have enjoyed and taken for granted maybe for 200 years. And is there anyone in this room today who would say that that right is not at risk? So that's what I'm concerned about, is how is this theory applied in the real world? Another example, can we have institutions like the Federal Reserve? Maybe somebody could have debated them as a matter of first principles back in, say, 1913 when the institution was first created. By the way, created by Congress and signed into law by the President of the United States. Congress could change it at any time. But can we have that kind of institution? That is not an abstract question. That is a really concrete, practical question that has incredibly important implications for every single person in this room and for hundreds of millions of Americans. Nate's question, civil society. Can you have, I was a line AUSA after I did my clerkships. I joined the U.S. Attorney's Office in Miami, one of the best jobs I ever had. Could the President of the United States fire me because of my party affiliation? or based on my race in violation of federal statutory protections? Again, not an abstract question. So I think this whole debate that we're having about the unitary executive theory really needs to be, from my point of view, as a citizen of the United States, as a dad, as a practical litigator, I'm interested in the question of how is it being applied in the real world, and how do we deal with those types of problems? And I hope that's not too long-winded an answer to your question.
I think
So-
Shannon wants to butt back in.
So the issue of the Fed is not, I mean, that's not really framing the question properly. The question is not whether the Fed can exist. The question is whether the Fed exercises executive power and the president should have the power to remove members of the Fed. Right, so can the Fed exist as an independent executive agency not subject to presidential oversight? Now, I'm sure everyone in this room has concerns about whether Donald Trump, has all of his minions running the Federal Reserve. But that's the system, that should be the system that we operate under, because Donald Trump will be responsible for the Fed and not able to say, the economy's their fault, not mine. If the President of the United States has, if any one person gets blamed for economic woes, it's the President. But now a president can say, it's not my fault. I have someone who exercises, authority under the law that I can't control. So this all goes back to a pair of cases from the 1920s and 30s where the stakes couldn't have been lower. Myers and Humphrey's Executor were a pair of cases about postmasters and the FTC. And I say the stakes couldn't have been lower because the cases were just two dead people whose estates were claiming that they should get back pay because they were wrongly removed as postmasters or commissioners on the FTC. So in that context, the courts decided this massively important issue, and in a 12-year period just completely flipped. The former president and Chief Justice Taft said in Myers, after looking at the Constitution, which is relatively silent on the question of removal, or completely silent on the question of removal, he looked at the first Congress and said, through a long excursion into how the first Congress looked at this issue and the fact that many of the framers of the Constitution were part of that body, and said that the first Congress understood that the president should have inherent in the president's power to appoint a member of the executive branch, he should have the power to remove members of the executive branch without control by Congress. In Myers with the postmasters, the Congress had said, you can remove a postmaster, but come to us first for permission. And in the FTC case, which these guys are litigating now, the removal clause, Congress had said you can remove an FTC commissioner for some form of bad behavior in office. But the question there wasn't, can the FTC exist? It's, can there be an independent executive branch body that is not answerable to the President of the United States, who is responsible for exercising and has political accountability for exercising all of the authority of the presidency. Myers in 1926 or 27, I can't remember which, said the president is the sole executive and should have the right to remove. 12 years later, the court just flipped and said, for a three-member commission, the rules are different, and we'll allow only for cause removal. But independence is the issue. The Fed is a really interesting exception to all of this, according to certain members of the court, or at least hints from certain members of the court, because we just can't have the president superintending banks. But the Fed has all sorts of regulatory authority. I litigated a case a decade ago dealing with debit swipe rules, where the Fed basically regulated how $3 or $4 billion of swipe fees exchanged hands between merchants and banks. And in that context, independence really is a problem because you don't have any political accountability. We can't, as citizens of the United States, we can't do a damn thing about the Fed. Once they're appointed, we're done. So it's not a question of whether the Fed can exist, it's whether the Fed can exist in this form. And this form, at least now, takes the Fed and removes it from the president's authority and superintendence.
Yeah, so a lot of great thoughts there, and appreciate that perspective. I do have a couple of responses focused on the Fed, and then maybe I'll turn it over to Nate to talk about other stuff implicating the FTC, which I will stay away from. All right, so on the Fed, you heard this point that, well, we can still have a Fed, it just doesn't have to enjoy any degree of insulation from presidential supervision, which is to say, you do not have the Fed that we have had since 1913, and that has served the American people and the American economy, by all accounts, extraordinarily well over an extraordinary period of time. So first, understand what the stakes are. I have a couple of thoughts about this approach that says, well, you need to have a Fed that is 100% under the thumb of the president. And first of all, just kind of fact to put this in perspective, the current administration is not taking that position in litigation that is now pending before the Supreme Court of the United States, and that I can talk about because I'm not involved in that case. Right? There's a case called Cook, which is now before the Supreme Court, and you could have the same unitary executive theory that is being propounded to you in all other cases and today, right, about all the executive power has to be vested in the President of the United States and under his complete control. But guess what? In the Cook case, the government is not contesting that the statutory for-cause removal provision is constitutional. Well, why not? I mean, if the theory is that you cannot have a Fed that enjoys any degree of independence from presidential control, why aren't they pressing this constitutional theory that the president should be able to fire the Fed for any reason, because of their party affiliation, because he doesn't like their decisions on monetary policy, because of their race? Right? Why aren't they propounding that theory? And the answer is, one, they don't have a consistent theory. The theory is not being applied consistently. It's totally ad hoc. So that's one problem. And two, I think it tells you something that even an administration that is kind of has embraced about as robust and radical an approach to the unitary executive theory as is imaginable, when it comes to the Fed, they are not willing to go along with the consequences of their own theory. That tells you something really, really important. Two, this gets to, for me, what is the fundamental problem, which is I don't have any problem with the idea that, there's language in the text of Article 2 that all of us need to follow, and sometimes you like the law and sometimes you don't like the law, and you'll get results that sometimes we agree with, sometimes you disagree with, but if the law clearly compels the conclusion that you cannot have an independent Federal Reserve, we live with that, and that's part of the price that we pay for living in a society governed by the rule of law. Where is that constitutional text? I mean, I've read the text of Article 2. I don't see where it says that, and you know who else hasn't seen where it says that? The current President of the United States, who's not pressing that theory, President Wilson, who signed the bill into law. I mean, are we to believe that every single President of the United States since 1913 did not understand the plain language of the vesting clause of Article 2? Because that's the theory that we're being asked to accept. And what I would suggest to you is the notion that every single president has reneged on their most fundamental duty, which is to take care that the laws, including the Constitution of the United States, be faithfully executed. The notion that every single president of the United States since 1913 has kind of just said, well, this is, my executive power for an office that has been entrusted to my care, and I'm just gonna look the other way. That on its face is not plausible. So something else is going on here. And this brings me to maybe the biggest picture point that I'd like to convey today in terms of where I think there might be some philosophical difference. And that is this. I would have thought, like intelligent people of goodwill can disagree about all kinds of things. I would have thought that it would be a matter of common sense, especially for conservatives, that at the end of the day, our overarching commitment should not be to an abstract theory, much less to any maximalist conception of that abstract theory. I would have thought that our overarching commitment at the end of the day should be to things that are a little bit more concrete, to our kids, to institutions that have made it possible for us to enjoy all the blessings that we have enjoyed for our entire lifetime, to the rule of law, to the preservation of democracy, right? I would have thought that our commitment would be to those things, and that when we're looking at an institution like just for example, the Fed, that most people would say is indispensable to the health of the American economy, that to the extent that there is room for interpretation, to the extent that there is discretion, that what we would say at the end of the day is maybe you take a theory into account, and certainly look at the words of the Constitution and what they have to say, but that the ultimate decision doesn't need to be dictated by our commitment to an abstract theory. This brings me back to why I became a conservative, sort of the Edmund Burke approach to conservatism, which was, I thought it was a foundational precept of conservatism, that experience is more reliable than pure reason, than abstract theory as a guide to human conduct. I thought that's why Edmund Burke and conservatives were appalled by the French Revolution and the Russian Revolution. Look, those guys who gave the world the French Revolution and the Russian Revolution, they didn't have any shortage of theories. They had lots of there were a lot of smart dudes, right? They read a lot of books. They had great theories. But what they thought was at the end of the day that they could make the world anew, that they could take institutions that had withstood the test of time, that had served people extraordinarily well, and just chuck them out the window in the name of an abstract theory. And that is where I think there's the fundamental philosophical difference that I would say, if you have clear constitutional text or a controlling legal authority that compels the conclusion that we cannot have a Federal Reserve, fine, show me where that is. If you don't, maybe we can take broader considerations into account.
Before Nathaniel, we get off the Fed, I'm going to interject a little bit. When Greg invited me, he said I could be a little active moderator to help balance you two out, join Shannon a little bit. And at least you seem to concede at the end of your wonderful little talk that the framers were doing something different than Burke. Burke lived in this, as much as Burkean, I think, influenced my, general conservative upbringing. He was living in a non-written constitution state, and our framers, you of course, bowed a little bit to the writing. And I submit that as a member of the Society of the Rule of Law, if the rule of law dictates a particular theory, we're committed to it. And when the framers were debating whether to create a privy council or a council of revision, and they went back and forth throughout the Constitutional Convention on this. They submitted, I think it was Gouverneur Morris, who stressed the point that Cannon made, which was, no, we reject again and again that there is some council that the president must listen to, and this is, I think, a Gouverneur Morris quote, but he was the strong proponent, but there was someone else on the committee with similar views, said, a weak president will hide behind such a council. A strong president will be thwarted by it, and we want accountability. And they kept returning to accountability, accountability, accountability. So that debate does color the meaning of the text that we have. It colored the text of the vesting clause and others. And one final thing, one off-ramp on the Fed. If the Supreme Court dodges that bullet, it'll be because they think it's not executive. It doesn't exercise executive power.
Could I
So
butt in on
let's just throw that out as a possibility with the Fed. I think these issues remain fascinating with regard to removal of the FTC, removal of other independent agencies, but there are grounds that we may find a cabinet office, let's say the Department of Agriculture, where the president has never removed the head of the, but that doesn't mean that the president can't, but the Fed may be unique for other reasons as well.
So I will, this goes to Amit's case a little bit, so I'll jump in on the Fed. Oh, this one's working better. Okay. A couple of points on the Fed. Point number one is I don't see how it couldn't be executive power, at least under the theory that the administration is proposing. Because the way the administration and Chief Justice Roberts in the City of Arlington case is he said there are three buckets. You're in the legislative bucket, you're in the executive bucket, you're in the judicial bucket. And none of those three can mix. So the Fed's got to fit in one of those three. Well, it can't fit in the legislative under that theory, can't fit in the judicial, so it's got to fit in the executive. So I don't see how, at least under that theory, it can't be executive power. Once you say it's not executive power, then I think you're sliding into our zone, which is okay. Then actually we got to define the executive power, and it's far narrower than the administration thinks. But I think what's particularly telling is the way the Supreme Court has addressed the Fed. Because what the Supreme Court has said is, well, there's just a special historical exception, and waved its hands. That can't be right, right? And they're relying on the Sinking Fund Commission, the First Bank of the United States, and the Second Bank of the United States. Put aside the Sinking Fund for a second. We can talk about it later. It actually supports Amit. Second Bank and First Bank of the United States also support Amit. But here's the key. Do we really think the First and Second Banks of the United States were not constitutionally controversial entities? That somehow we can look and say, well, there's a special historical exception that everyone understood for central banks? I mean, those were the hottestly contested institutions in early American history. So I don't think the Supreme Court, frankly, has the courage of its convictions to come out where the theory that they're at least going to embrace, potentially, would lead them to. And I think that tells you all you need to know, which is there's not really a there if you're not willing, from a rule of law perspective, to actually embrace the consequences. And for good reason. We would end up being, if you accept that, the only developed nation without a central bank that is insulated from political control. And it's actually really important, because what you don't want to have happen is you don't want your president, who's about to get elected, to juice the economy so that he gets reelected and then have massive inflation, right? So there are really important reasons why developed economies have a measure of insulation. But I guess one other point that I would end on. Even the Fed is accountable. Congress creates it. Congress can amend it, right? Where's Congress in this whole conversation? They're elected every 2 years in the House of Representatives, every 2 years on 6-year cycles in the Senate. They've got a tremendous amount of control. They also have the power of impeachment. And by the way, the president has the power of removal. All we're saying is the president can't remove you unless you've created misconduct, malfeasance in office, right? There's some good cause. He can't just throw you out because you've decided.
Why is there any limit?
Why is there any limit in what?
Yeah, well, I was going to, before I went off on my rant, I was going to.
I have another rant too.
Okay,
so.
good. We'll bring Shannon. We'll bring Shannon in. But do we all agree? Do we all agree that Congress can't create an executive branch agency and forbid any removal?
So Congress actually has done that for quite a large amount of time, depending on how you look at it. Territorial courts were first created in the 1789 when one of the first acts was to create territorial courts for the Ohio Territory, then the other territories, then the Court of Claims, actually.
And were they challenged and upheld?
The Court of
For
Claims.
the removal.
Well, so no one ever contested it, which I think is a good indication that everyone thought they were constitutional, right? You've got all this uncontested practice where the president's signing into law and there being none of the litigants, nobody's contesting the fact that the Court of Claims, for example, which is definitely an executive branch agency, right, can have good behavior. So I think there's actually quite a lot of historic practice that at least for some of these, Congress can do that. But I think the other answer is nobody less than Justice Kavanaugh, when he was then Judge Kavanaugh, said, well, we've liquidated the meaning over time, starting after the Civil War in the 1880s, and we've come to a conclusion that where it's a multi-member border commission, where there are these limits on presidential power, but not absolute limits, then it's constitutional. I think this is Amit's point, which is there has to be some room for lived experience here, especially where the text of the Constitution is silent.
Shannon first.
So I want to take great and friendly umbrage at Amit's point and not invoking Woodrow Wilson as some paean of constitutional authority. But that's not. The theory point. look, this goes well beyond theory. The political accountability is incredibly important. Look, if Donald Trump had authority over the Fed, it might cause people to think about whether they should vote for Donald Trump. I mean, but that's an incredibly important point. There's a political accountability, and it's not just theory. It's, look, the president, you're going to elect the guy who's going to have authority over these agencies. There isn't this fourth state. There shouldn't be this fourth administrative state that's going to go on and do whatever it does, no matter who's in charge, although generally lean left. Instead, when you elect a president, you're electing all of those. You're electing every one of those agencies. So the FTC is going to be accountable to the president, and the CFPB is going to be accountable to the president. So this, I think, is well beyond theory. It's actuality. And we have a constitutional structure for a reason, and it's worked for a long time. The fact that there are threats to that, from a president, and it didn't start with this president. I mean, you look at Obama's just rewriting immigration law under the guise of enforcement. There are precedents for what this president is doing, and the erosion of what he's doing will be used by the next president. But those questions, the questions of does Title VII apply? Can the FCC do these sorts of things? There are all sorts of other protections. The First Amendment is really meaningful. But at the end of the day, I think this goes well beyond theory, and it has practical ramifications. And the fact that we have had this fourth state has done exactly what Todd mentions with Gouverneur Morris, lets a president and a Congress hide behind this administrative state. And that's where accountability is eroded.
Let's have brief rejoinders, and then I want to return to some other things where I think we all agree that on the prerogative, what I call the prerogative powers, but brief rejoinders on.
Yeah, so brief rejoinders. One is on this issue of accountability, which is something that we hear over and over and over again, that our hands are tied and we have no choice but to take these institutions that have been around for 100, 150 years and to toss them in the garbage, because it must be the case that every single exercise of power that is outside the auspices of the legislature and the judiciary must be exercised by someone who is accountable to the American people. Is that a fair recitation of the principle? Okay, so let me ask you a really practical question, because I think we agree this is far beyond theory. You don't like what the president is doing, say, in terms of controlling interest rates today. How would you hold him accountable? He's a second-term president. You're never going to get a chance to vote for him ever again. And so, you're never going to get a chance to vote for him ever again.
Well, that remains to be seen.
Yeah, I mean, don't even get me started on that, right? So, but what kind of a theory is it that would radically change the fundamental nature of American governance and that has zero practical application to any second-term president? I mean, right off the bat, you've got a huge, huge problem. Let me make one more rejoinder, and that is to this issue of, well, if the law requires something, we just gotta live with it, and I think we all agree with that. But you may notice that there was no answer to the question that I posed, which was, are we really to believe that every single president of the United States since, say, for example, Woodrow Wilson, has misunderstood the scope of executive power? And what I mean
I can name a lot.
Yeah, what I mean by that is this. Like, at a minimum, we're talking about things that are contestable, that reasonable people can disagree about if you look at the text of Article 2, and especially if you look at the text of Article 2 in light of super broad language in terms of expressly enumerated congressional authorities, but reasonable people can disagree about these things. And this brings me to, I think, what may be one of the most important things that I care about, which is who gets to decide, right? To the extent that there are these debatable questions that we can all disagree about as a matter of first principles, Why is it the case that 5 unelected, politically unaccountable judges should get to conclusively decide those issues for more than 300 million American people, especially when we're talking about institutions that have been around for 150 years? Why can it not be the case? Why can the president not go to Congress and say, you know what, I'm not sure that we should have a Federal Reserve. I'm not sure that, I should not have the power to call up that broadcaster and to say, I'm going to cancel your license if someone is saying things that I don't like. I want that power. And why can he not go to Congress and ask Congress to give him that authority? And, if the answer is Article 2, the text, again, I say, show me where that text is. But if that's not the answer, if reasonable people can disagree with this about things like that, I would have thought that the answer in a constitutional republic would be that we can trust the people's elected representatives to maybe engage with these great questions. I mean, these are, to some extent, honorable. This is an honorable debate. These are great questions.
There are two other panels, too, that will
Right.
help address those
I mean,
legislative and judicial responses.
Yeah, and I've been going on for a while, so I'll stop. But I think to some extent, some of these separation of powers issues we're discussing, they don't have to be formulated or conceptualized as purely legal questions that have to be decided conclusively as a matter of constitutional law by 5 unelected, politically unaccountable judges. And there is room for us to say, as a people, as a country, that there are great questions that are worthy of a great democracy, worthy of a great people, and we can debate those questions through ordinary political processes and not take extremely debatable, extremely contestable views of just one provision of the Constitution and chuck out institutions that, like I said, have served the American people and the world extraordinarily well over an extraordinarily long period of time.
I will be very brief because I know we've got to move off of the Fed and removal power. But I would just add to what Ahmed is saying, well, 2 things. One is, why now, right? Even if you assume that this is up to the Supreme Court, why do this now, right? In this particular moment, we are in a uniquely dangerous time for a constitutional republic. Why now go and invalidate a precedent that has existed since 1935? Why get rid of institutions now that have existed since at least the Interstate Commerce Commission in the 1880s, if not earlier, if you take my view, right? Why do all of this at this moment when you have discretionary certiorari jurisdiction? You don't have to do this. They're choosing to do this, right? That, to me, at a minimum, is a deep problem. I would also disagree, if I could, with the notion that prior presidents were somehow engaged in similar kinds or predecessor kinds of uses of executive power. Whatever one thinks about the Obama administration, whatever one thinks about the Bush administration, which I think had pretty expansive views of executive power, we are just worlds and away different now, right? These are apples and oranges that I don't think we can possibly compare. We can't say the original sin here was started 10, 15, 20 years ago. This is just so manifestly different, right? At the point at which we're taking the position that the president can go, point to an AUSA, and fire them because he doesn't like the fact that they've donated to a Democrat. That's a problem, right? That is totally and completely different and is a type of executive power or a conception of executive power that has never before been asserted by any president. And I would add one final piece. This administration is even asserting executive power where the Constitution explicitly says he doesn't have that power. Take the Appointments Clause. There is a case right now. It's the case involving the Inter-American Foundation. It's called Aviel v. Gore, in which the administration has taken the position it has, wait for it, inherent Article II authority to appoint acting officials, regardless of the law Congress says. Last time I checked, the text of the Constitution said that officials have to be appointed by the president and confirmed by the Senate. The administration's position is that doesn't matter. So I don't get why we get to pick and choose and say, I like this unwritten piece of Article II that never talks about the removal power, but I get to ignore the written part of Article II that talks about the Appointment Clause. This doesn't add up.
Moving into my territory. Thank you. Yes, and that's why I think the distinction matters. I'll make one brief attempt to go back to that. And then, I would prefer that we distinguish the hard questions and the easy questions that revolve around the president's stewardship of the executive branch. And then everything else that's a prerogative power, we say, whatever the hard issues are under unitary executive, this has no bearing, no relevance to this claim power. And so let me just throw out a couple of them. We came up with, helpfully with Nathaniel on our pre-call, I came up with 24. I'll add the 100 million smackaroos as 25. But let me just talk about eliminating a department or virtually eliminating a department that Congress has created, impounding most appropriated funds for a particular purpose because it supposedly affects his Article 2 power. Can we identify some kinds of claims that we think not only don't have any pedigree under unitary executive properly understood, but also don't, to get to your last point, Nathaniel, don't seem to have any colorable Article 2 claim.
So-
Shannon, I'll let Nathaniel go first, but can I goad you into questioning at least some of the current claims?
Well, I find the use, both the foreign and domestic use of the military questionable. Certainly outside of the District of Columbia, which is a federal territory, the use of, the president's use of military power for domestic law enforcement purposes is the sort of thing that we would have been, absent an insurrection, we would have said in the Bush administration, forget it. We can't go there. Using presidential authority to blow up boats in the Caribbean that seemed to just be a matter of law enforcement is problematic. Now, I'm not suggesting there aren't situations where that can't be a legitimate use. I mean, there has been a sort of congressionally authorized war on drugs in Central America for quite some time, and we snatched the head of Panama, who ended up in jail in Miami. But that's where I start is sort of the use of the military.
So let me just touch on one of the ones you mentioned, which was destruction of executive branch departments, right? And I think this is an important one to highlight for two reasons. First, it eliminates Congress's constitutionally defined role in creating executive departments, right? So one of the things Congress does is it creates the executive branch departments. Nobody previous to this administration, and there were lots of conservatives who disliked the Department of Education going back to the Reagan administration. Nobody ever thought you could wake up one day and say, I'm going to sign an order that's going to fire everyone from the department. There's no more Department of Education. It's gone. Same for the CFPB. My firm is going to bring a case relatively soon about another such entity, right? You could just wake up. There's a statute on the books. It says the department has to exist, but it's gone, right? That's got to be wrong, right? I mean, we think we can all agree on that. And here's the other problem. None of these doctrines are going to fit, frankly, a faithless executive. Because what the executive branch has done in those types of cases, it said, well, look, the way Congress wrote the statute, sure, it created a CFPB and gave it billions of dollars of funding. It created a Department of Education and gave it billions of dollars of funding. But it only outlined a couple of provisions where the executive shall carry out certain activities. So we're going to keep one rump guy around. And that person, they're going to do the minimum shall things, the report that has to get issued to Congress every year. And we're going to ignore all the may things, right? That it may regulate in this, it may do that, it may do, this enforcement action. And that means we've complied with the law. Does anyone seriously think that that is a faithful execution of the laws that Congress passed? And is that any way to run a system that Congress is going to have to delineate in excruciating detail every single shell activity down to the lowest level minutia of you got to have a guy sweeping the floors, or otherwise the president can just wake up one day and declare because he runs Article 2 he can destroy the agency? That can't be right.
Yeah, so there's so many examples that we could talk about. One that is top of mind for me is tariffs. Huge economic, practical impact. If you look at the briefs that are being filed in this case, the government in its opening sentence of its brief invokes Article 2 of the Constitution. Now, tariffs are taxes, right? And everybody would agree, based on first principles, based on plain constitutional text, that the taxing power is not just a legislative power, it is the quintessential legislative power. We fought a revolution. We fought a revolution to vindicate the principle of no taxation without representation, and we did not, our framers, when they risked it all for that proposition, they did not mean a representative king. They did not mean a representative president. They meant parliamentary representative institutions, right, that would decide when the American people are taxed. And what is the authority that is being asserted today? Again, not theoretical, practical. It is a so-called emergency power to impose emergency taxes on the American people. And it is a virtually, as every court to have considered the question so far has held, it is a virtually unlimited authority that is being proclaimed. And what do I mean by that? I mean no limit on what kinds of goods and services can be taxed, no limit on the amount of tax that is imposed, no limit on how long that tax lasts, no limit in terms of procedures that have to be followed before the tax is imposed, no substantive limit on these are the policies that will be effectuated by the tax. It is a virtually unlimited authority for one man to tax
But
the,
he
to
likes
tax the
it
American
so
people.
much.
Well,
Yeah,
but even there, Amit,
let me just finish this one point, because then the argument is, well, the president is asserting an authority that's based on a statute, and it's a statute that, by the way, never uses the word tariff. It never uses the word tax.
Okay, Shannon.
no,
And here's my point. So this is the point about the unitary executive theories. You have people saying, well, that language in the vesting clause, a handful of words in the vesting clause of Article 2, we've got to embrace the maximalist interpretation of that. But what about the vesting clause of Article 1? So if there's going to be a comparable sort of like, hey, our hands are tied by the vesting clause of Article 1, just like they're tied by the vesting clause of Article 2, then I'm willing to have the conversation with you. But if the argument is we have to entertain the president's assertion of an emergency taxing power, which is virtually unlimited, and that is consistent with originalism or textualism, I mean, that is, I think, something that for me is really, really hard to stomach, because it shows that these abstract principles that are being invoked are in fact not being applied in any kind of way that is coherent or that is consistent with 200 years of American constitutional tradition.
See, I mean, I agree with you at the end of the day on the tariff power. I don't think it has anything to do with unitary executive. It's just a really bad statutory interpretation of a statute that's been on the books for 70 years, IEPA, and nobody has ever even contemplated that it has anything to do with tariffs. That's just bad execution of the law. And that's exactly what other administrations have been doing. And the Supreme Court has developed a doctrine to say these sorts of major questions, we're not going to allow, the executive to take a statute that's been on the books forever and find, hey, guess what? We're a lot smarter than you. We've found that it actually has allowed presidential tariff power for 70 years. So I don't really view that as an example of unitary executive. Todd, one thing that the president has done right at the beginning, and I think you and I would agree on this, his conception that he can just declare what the jurisdiction of the United States is for citizenship purposes, unilaterally, right? The president can declare that anchor babies, as they're called, have no citizenship going forward. I don't think anyone who understands the Constitution. There is an argument that the jurisdiction of the United States might be defined in a particular way, but it sure as hell isn't the president's authority to do so.
Absolutely. Let me throw one. I wasn't sure where you were going to go with that, and embrace my view, but now I can agree. Let me throw out one other, which is I haven't followed in great detail of the appeals from the Portland and Chicago. I understand one judge in the Ninth Circuit is going to seek to go en banc regarding the recent panel. But one of the areas is when there is a emergency power, does the president have unreviewable discretion in declaring that emergency such that the court can't subject, or that the standard the court would apply is extremely deferential? Alan, in the introduction, read from the census case. At least in that case, Chief Justice Roberts said, we're not naive, we can't be blind. And by the way, as a public interest litigator, I said, hallelujah, I wish we could apply this principle in more cases. I hope it isn't just this census case. So where are we as a panel on the president's? Are there some statutes where Congress has given him unreviewable emergency power? Is that conceivable? Has Congress done that frequently? Where are we on this issue?
So I just two small points, because I think this is a broad one. Number one, there are many break-in case of glass powers that sit within the federal government. This gets back to the faithless execution problem, right? Those are supposed to be broken in emergencies. I like larger tariffs is not an emergency. Even if you thought IEPA's word regulate allowed you to impose tariffs, which, by the way, IEPA's never been used to do that. It's highly contestable that, anyone would even plausibly think that the word regulate would mean tariff. But even if you get there and say there are some tariffs, you can impose a tariff because we've just gone to war and you need to do it for 30 days. Okay. But that's not this. And so it's got to be that it's reviewable. And here's why I know it's reviewable. It's not just the census case. Take the student loan case. So Biden, to try and relieve student loan debt, takes a dormant emergency power statute that was passed after 9/11. And what the court says is, no, we're not going to allow you to take that dormant emergency power statute, which was used for forgiving loans after 9/11 in extraordinary circumstances, like for service members, and use that to waive student loans broadly for everyone in the United States. I think it will be a telltale sign how the court rules on the tariffs case. Because if it says, IEPA, vague emergency power statute, you can take it, there's no way to square that with the student loan case. You just can't, right? If Biden couldn't do it with student loans, Trump can't do it with IEPA. So my view, especially as a litigator who's litigating these cases, is of course the court's got to be able to look behind the curtain and review these things. And if it can't, then we've elected a king.
And so a short, immediate answer to your question is that there can be circumstances in which one could imagine circumstances in which the mere declaration of the emergency, say under the National Emergencies Act, may not be subject to judicial review, but that only gets you so far because that declaration of an emergency then triggers other statutory authorities, like under the IEPA statute that you mentioned. And at that point, the question is one of statutory interpretation. What does that statute authorize when the president declares an emergency? So, that's an important distinction. I totally agree with Nate that what the Supreme Court says about the major questions doctrine in the tariff case is going to be a really, really important reveal for exactly the reason that Nate articulated, and that is that the amount that is at stake in the tariffs case in terms of how much, like just the enormous kind of practical real-world impact is orders of magnitude greater than other cases in which the court has said you have a major question. And so if we're going to have neutral principles, if we're going to have coherent law, then the principles that applied to undo President Biden's student loan program should also be applied in this administration to something that is orders of magnitude more significant.
I am going to
125 left.
I will briefly disagree with Amit, and it's the only brief thing I've ever said in my life. I think it's got to be that also in certain circumstances, you have to be able to review the president's declaration that there's an emergency. Take Portland, right? Take Chicago. If the president can just wake up and say there's an insurrection and a court can't look behind that curtain, imagine the scenario. And to me, it's extraordinary that this court, which is willing to review every administrative agency with a fine-tooth comb, isn't willing to say the obvious. There is, or maybe not, we don't know, right? But that there's not an insurrection in Chicago, right? That we got to be able to not suspend disbelief on that.
Yeah, and just to be clear, I don't disagree
Yeah.
with any of that, and I was not suggesting that
No, I know you weren't, but
declarations of emergencies
yeah.
across the board are judicially unreviewable.
Yeah.
I'm saying even if they are in some contexts,
Yes,
like
yes.
the National Emergencies Act, you still have other
Yeah.
forms of judicial review.
Shannon, 30 seconds left. Anything in conclusion?
Well, I think it's really hard to make those determinations, and I think the court is hesitant to, especially where it involves shared powers between Congress and the president in the areas of foreign affairs. So the declarations of emergencies that have foreign affairs implications, I don't know why the 9 on First Street have a better view than anyone or could make those determinations. But I think they will, in some domestic contexts, make that kind of call.
Good. That's a good distinction to end on, and thank you all very much.